Inheritance law sounds pretty simple, doesn't it? Someone passes away and they leave their stuff to someone else. But what happens when that someone else is the person who killed them? Or what if the heir is desperately trying to avoid getting the money? Today, we're going to dive into two real-life legal battles that really push the boundaries of who deserves to inherit.
So let's just ask it straight up. Can you inherit from someone you killed? I mean, morally, you'd think the answer is a hard no, right? But when you look at the actual law, the answer gets surprisingly complicated. Let's get into it.
Okay, so meet Charlotte Mahoney. Back in 1961, she was convicted of manslaughter for killing her husband. Now, under the inheritance laws in Vermont at the time, the rules were crystal clear. As his surviving wife, with no kids, she was legally entitled to his entire estate. The law, as written, said she should get everything from the man she killed. You can see how this created a massive headache for the courts.
So the court is in a real bind here. Do they just follow the letter of the law and, reward a killer with an inheritance? Or do they basically invent a new rule to make sure justice is served? This is where the story starts to get really interesting.
But here's where the story gets a whole lot murkier. That manslaughter conviction, it didn't exactly tell the whole story. Research from Professor Carla Spivak into this very case shows that these kinds of tragedies are often the terrible endpoint of years of violence and abuse within a family.
Digging through old news archives, Spivak found evidence that was never fully brought to light. Charlotte had testified that her husband punched her, that he slammed a car window on her hand. She said he chased her into the house with a rifle, screaming that he was going to kill her. A doctor even documented bruises on her neck and jaw. Suddenly, this whole case looks completely different, doesn't it?
So what does a court do? How do you follow the law, but also, do the right thing? Well, to get out of this mess, they reached for a really clever legal tool called a constructive trust.
See, back then, Vermont didn't have a specific law for this, what they call a Slayer statute. So the court was kind of flying blind. They really only had three ways they could go. Path 1, stick to the law, no exceptions, and let Charlotte inherit. Path 2, just ignore the law and say she gets nothing. Or Path 3, something a little more creative.
And that third path is the constructive trust. It's such an elegant solution. It's not a real trust that someone sets up. It's more like a legal fiction a court creates to stop what's called unjust enrichment. Basically, the court says, okay, the law says you get legal title to this stuff, but it's just plain wrong for you to keep it, so we are forcing you to be a temporary trustee, and your only job is to hand that property over to the people who actually deserve it.
The famous Justice Benjamin Cardozo put it perfectly. He said, a constructive trust is how the conscience of equity finds expression. It's the law's way of stepping in and saying, whoa, wait a minute, this isn't fair, and then fixing the outcome without having to tear up the existing laws.
So you'd think, great, problem solved. But nope, the legal system, right? There's always a catch. The Vermont Supreme Court loved the idea of a constructive trust, but they ruled that the probate court, the one handling the inheritance, didn't have the power to create one. So they sent the case back and told Howard's family, you need to go to a different court, a court of equity, to get this done. It's a perfect example of how knowing the right procedure is absolutely everything. The court also drew a really important line in the sand here. The whole idea is that a killer shouldn't profit from their crime. So that means this Slayer rule applies to intentional killings, like voluntary manslaughter. But it doesn't apply to unintentional deaths, like involuntary manslaughter. It's the intent that matters. Okay, so we've seen how the law can stop someone from getting an inheritance they don't deserve. But what about the total opposite situation? What if you're supposed to get the money, but you desperately don't want it?
Seriously, what if you were the rightful heir, but for your own reasons, you want to turn it down? It actually happens more than you might think. And yep, there's a specific legal tool just for this.
That tool is called a disclaimer. It's basically a formal legal way of saying thanks but no thanks to an inheritance. And people do this for all sorts of strategic reasons, usually either to dodge taxes or to keep creditors from grabbing the assets.
And the way this works now is way simpler than it used to be. The law does this kind of cool thing. It's almost like a little bit of time travel. When you disclaim an inheritance, the law pretends that you died just moments before the person who left you the money. So the property just skips right over you and goes to the next person in line.
But this disclaimer trick, it's powerful for sure, but it can't get you out of everything. As one man found out the hard way, you can use it to dodge some people, but you definitely can't use it to escape everyone. All right, let me tell you about a guy named Roan Dry. When his mother passed away, he was said to inherit her entire estate. That sounds great, right? Except Rohn had a very, very big problem with a very, very powerful creditor, the IRS. And when I say a big problem, I mean a really big problem. We're talking $325,000 in unpaid taxes. His whole inheritance was only going to be about $233,000. He knew, without a doubt, that the second he touched that money, the IRS would swoop in and take every last cent.
So Dry hatches this, honestly, pretty clever plan. Step 1, he formally disclaims the inheritance. Under state law, that means the estate skips him and goes straight to his daughter, Teresa. Step 2, Teresa takes the money and sets up a trust fund. And who are the beneficiaries of that trust? Well, Teresa and her parents, including our friend Rohn Dry. It was a slick way to keep the money in the family. Or so he thought.
The IRS didn't buy it, and the case went all the way to the Supreme Court. And this is where the legendary Justice Ruth Bader Ginsburg just slices right through the whole thing. She said, look, the moment Dryle had the choice to either accept the money or reject it, he had control. He had the power to take it himself or to channel it to his daughter. And that power, she argued, that ability to direct where the money goes, that is a form of property.
So here's the bottom line. The Supreme Court's decision was unanimous. A federal tax lien attaches to your right to inherit property even if you try to disclaim it. Your state law might say you never technically owned it, but when it comes to collecting taxes, federal law gets the final word on what counts as property. And for the IRS, the power to choose was more than enough.
So what do we take away from these two completely different, really wild stories? They show us that the law isn't just some rigid, unthinking machine. It has these built-in safety valves. Whether it's a court using a clever tool like a constructive trust, or federal law stepping in to overrule a state loophole, the system has ways to make sure that its own rules don't lead to a result that is just fundamentally wrong.
And that really leaves us with this huge question, one that lawyers and judges wrestle with all the time. In a system that is built on clear, written rules, when is it okay to let our sense of fairness and justice step in and actually change the outcome? It's something to think about.